We are recording this because we're going to post it on our website for anybody who might want to just learn about this after the fact and not in person. But I'll start by introducing myself. I'm Tracy Kossoff. I'm here from State Engineer's Office, and Marie is here with me. We have Nora from the CWCB who's going to do part of this talk. Savannah's here from the Attorney General's Office, and we got a couple of folks here from our local Division 6 office. Thank you, Brian and Christina, for joining us as well. So, but without any further ado, I'll jump into it. It's pretty brief presentation. There's a beginner's guide at the back. You might have seen when you walked in. It's just like a front and back. It's kind of a good quick reference because it can seem complicated. It is kind of complicated, but that quick reference, if you're trying to make sense of it, could be helpful. So I just want to point you to that. But let me jump into it. We're going to be talking about ag water protection water right that we're going to abbreviate, call it Ag-PWR tonight. And we're here because this was previously only allowed in the South Platte and the Arkansas River basins, but in 2024, the legislature expanded its use statewide. And so that means a couple of things that we'll go over tonight. Oh, sorry, we're already there. So tonight we're going to do an overview of what Ag-PWR is, and then we're going to talk about DWR's substitute water supply plan rules that go along with that, and the CWCB's criteria and guidelines that also go along with Ag-PWR. So what is Ag-PWR? It's a special type of changed water right, recently expanded by the legislature to be allowed statewide. What is Ag-PWR? It's a really unique type of change of water right. What it's going to do is decree the historical consumptive use of irrigation water in the water court process. The use of the changed water is flexible. It's not identified in the decree. That's really unusual. Any other type of water right change that you're going to do in the water court, you need to say what you're going to use it for. I'm going to use it for municipal use now. I'm going to use it for in-stream flow now. That's not necessary in an Ag-PWR. Pretty much what you're doing in the water court part of it is decreeing the historic consumptive use and also quantifying the return flows. And the rest of it is taken care of down the line. So in the future, after you've gotten that water court decree for an Ag-PWR water right, in the future, you can use up to 50% of the water for different uses, and those different uses can vary from year to year. So one year you might use it for one type of different beneficial use, and then another year you might use it for yet another type of beneficial use. It's flexible in that way. And maybe before I go on, I do want to say that although that this was allowed in the South Platte and Arkansas River basins in 2016, no water user has done this. So somewhat what I'm talking to you about tonight is hypothetical because no one's gone through the process to really prove it up, work out some of the kinks. Some of the unknown questions have not been answered. Although, you know, the law that the legislature put in place, it provides like a lot of sideboards, and we have rules that have a lot of sideboards. There's still some things that, you know, we're not exactly sure because nobody's done it yet. So I'm going to go through an example of how this works. So the starting point is an irrigation water right that somebody's currently using. So folks are using water for irrigation. They decide that they want to go to the water court to decree a change of water right for an Ag-PWR type of use. They're going to be in the water court for doing that change process, and that is going to quantify the historic use through that change process. So there's going to be an engineering analysis looking at the historic use of the irrigation water. And that water court decree is also supposed to identify protective terms and conditions, standard things to protect other water users on the stream. The next step is, after that change has been decreed in the water court, when the water user is ready to use it for a different type of beneficial use, that is done through a substitute water supply plan or an SWSP. The SWSP is an application to the state engineer's office for a temporary change of use. So when you are ready to use water for that change type of use, you're gonna submit a SWSP application. That's gonna describe what the new use is. But according to statute, you can only use half of the quantified amount of historic consumptive use from that irrigation water right. The other half has to stay in irrigation. That's another unique feature of an Ag-PWR water right. And then that SWSP is gonna have to include additional terms and conditions to prevent injury. So that step is done at the state engineer's office, not at the water flow. There's that piece about the half that you're not using for a new use, it stays in irrigation. So a little bit of information about that, at least half of the water needing to stay in irrigation. The statute lays out how this works. There's two ways of essentially overseeing that 50% of the water that stays in irrigation. So the first way is through a conservation program. And so this is coming right out of statute. It says that that ongoing irrigation can be overseen by a conservation program that might be federal, state, local, or nonprofit, a program that conserves the land historically served by the irrigation water right, such as any of these programs. And this is not a complete list. There might be some other type of conservation program that meets the criteria and statute that's not listed here. So this is including these types of programs, but not limited to. So we've got Colorado's Conservation Easement Program, Fish and Wildlife Service Easement Program, NRCS, CPW, their easement programs, or a county open space easement program. So that's one of the ways where ongoing irrigation can be overseen. The other way is something that was created by the legislature, this concept of agricultural water protection and agricultural water protection program sponsored by an eligible entity. So this number two, this ag water protection program that could oversee that ongoing irrigation water use. That's the part of the program that is run by the CWCB. And Nora's gonna give more details about that later in the talk. So just a really basic example of how this might work on one farm. So right now in our very basic example, we've got irrigation water going to a 240-acre farm. This water user decides, okay, I want to do this Ag-PWR process. So what they're going to do is they're going to step one is to go to the water court, decree their historic consumptive use and their return flows. So this is this chart here is going to somewhat break down what that might look like in really simplified terms in that water court decree. So the irrigation water right is for 12 CFS. Typical diversions are 10 CFS, and of that 10 CFS that's been applied, 6 CFS of that has historically been consumed, 4 CFS has historically been return flows. This is just a really simplified graphic because if you've been involved in one of these court processes, this analysis, it does entail an engineering report. They're going to look at months of the year by year varies. So this is just super round numbers, for example. But in any case, I think you all know when we're applying irrigation water to the land, not all of it is consumed. Some of it is return flows. All right, so then they've decreed this first part, the amount that's consumptive use, the amount that's return flows, and then they decide, okay, I have a new use, so I'm going to apply for a substitute water supply plan to use that for 1 year for some other purpose that I've identified. In that SWSP, I can use 50% of that decreed historic consumptive use. So in our example, that would be 3 CFS. And then 50% is going to stay in irrigation. I have another little breakdown. So when you're using water for a changed purpose, you have to maintain those historic return flows. And so when I'm taking half of it to a new use under the SWSP, I have to make sure that half of those historic return flows are also maintained for other water users on the stream to be satisfied. That other half of the water that is going to stay in irrigation, it's going to continue to replace that other half of the return flows. So my SWSP is for half of the consumptive use and half of the historic return flows. And then the ongoing irrigation takes care of the rest of it for the system. And then in most cases, you're going to look at drying up half of that land because you're only going to apply half of the water going forward. You're going to take half of the water to the new use. And then that ongoing irrigation needs to be covered by one of those conservation programs or by an ag water protection program. So I know that's a lot of steps, but that's kind of the overview and the most basic example. Any questions on that before I move on? Okay. So something I want to point out, the legislature put a limitation on Ag-PWR, and in the SWSP, an Ag-PWR cannot, and I'm just going to read it to you, facilitate the diversion of water between water divisions by direct diversion, exchange, replacement, or other means. So it's a broad statement saying that you can't use Ag-PWR to facilitate the diversion from one of our big water basins to another, from the east slope to the west slope, from division 6 to division 5. It's just not allowed. So just good for people to know that that's a limitation. Okay, the timing of all of this. Kind of click all these things in here. Okay, so first step, the owner applies to the water court for an Ag-PWR change. A change of water right process in the water court, it can take a while. And so that's why I put a question mark there. I don't know how long that's gonna take. You know, minimum of a year. A year would be really fast for such a process. So after that, they finish their water court process, then they have a decree. Now they have an Ag-PWR water right. You could see the decree that has Ag-PWR as a type of use and irrigation, continued irrigation under your water right, as you always have, as a continued use. So if you seek that in the water court, I think you can continue to irrigate as you always had, but then you'd also have this flexibility to do Ag-PWR if you wanted in the future. Then some time can pass until you're ready to use that half of your water for a different beneficial use. So who knows how long that is, but then eventually you obtain a lease from another water user who wants to use half of your decreed water right. So you obtain a lease, and then when you're ready, you apply to the state engineer for an SWSP, and you have a way to have that land in one of those conservation programs that oversees ongoing irrigation. It usually takes the state engineer's office 3 months to review an application for an SWSP. I usually tell people, well, you know, if you want to operate this during the irrigation season, you're safe pretty much if you apply like at the beginning of the year. That way, we've got 3 months to tell you before irrigation season comes. We can give you your approval by then. So that takes about 3 months. We issue the approval. That gives you 1 year of operation under the SWSP for the changed use. And then, unlike other types of SWSPs, where usually you just get approval for 1 year, and then you have to submit an application to get another year, and then another application to get another year. Ag-PWR is unique because you get that first year, and then if you want to operate for year 2 and year 3, you can just tell the state engineer you want to repeat that in year 2 and year 3. So unique in that your approval, we could just say gets you 3 years. After 3 years, if you wanted to do it again, then you would submit a new application for an SWSP. You don't have to repeat the same thing year after year. You can do it 1 year, not do it the next. You can do one thing 1 year and apply to do a different thing the next year. There's no time limit. You could do this year after year after year if you wanted to. No limits like that. There are opportunities for other water users to comment on what you're trying to do throughout this process. And so the first one is water users could request to be a party in your change case. And that, just like any change case, gives them the ability to work with you throughout the court process. Number 2, like all of the SWSPs that the state engineer reviews, the state engineer is going to require the applicant to submit a notice to the SWSP notification list. So anyone who's subscribed to that list is going to know that you have applied for an SWSP. And if they want to provide comments on your application while the state engineer is considering it, that's an opportunity for them to say, you know, please consider this about this particular water right. One unique thing about Ag-PWR SWSPs is that the state engineer needs to issue what is called an initial decision. Let's assume that they're approving. They're going to submit an initial decision approving your SWSP, and that just sits there for 14 days, and it gives folks an opportunity to provide comment on the initial decision before it's final, before you can operate. So there's just like one added opportunity for folks to comment on this operation. Okay. Any questions? All right, so I'm gonna have a similar example to what I went over for one farm in a sort of a larger scale ditch company example. Okay, so we've got a ditch company here within this dashed boundary, and then another parcel, another farm that's outside of the ditch company, but they're all using water from the same stream system. And we're gonna have some of these farms apply together in the water court for an Ag-PWR change. So they apply to the water court together, all those same things happen, especially they're going to quantify their historic consumptive use and their return flows. They've done this together in one decree in this example. So we haven't really talked yet about the Ag Water Protection Program. Nora's going to talk about that later, but one of the types of eligible entities that could do an Ag Water Protection Program to oversee ongoing irrigation is a ditch company. So maybe in this example, the ditch company sets up an Ag-PWR program to oversee people who got Ag-PWR within their ditch company boundary. That's one scenario. So some of these fields are going to enroll in the ditch company's Ag Water Protection Program. And then these other fields, they're in a conservation program. So that's their way of covering their ongoing irrigation. And then, you know, like in our other example, when these folks are operating under their SWSP, they dry up half the farm or half of that field, and then they take the water to the new use. So there is some unique language for, I'll just read it to you all, for folks involved in a ditch system. So statute allows that water not being leased can be used on the historical property or on another property served by the same ditch system. So the way I interpret that is that those folks there within the ditch company boundary, they could work together to decide what lands among themselves they want to dry up. It doesn't all have to be like farm by farm. They could maybe kind of play around with that among themselves. There's that added flexibility. Okay, why are we here talking to you now? That's because the 2024 legislature expanded ag power from just the South Platte and the Arkansas to statewide. So, now you all have an opportunity here that you didn't have in the past. The SWSPs that I've been talking about, the way that you use water for that 1 year at a time, that is actually guided by some SWSP rules. So these rules talk about like, okay, what does an application have to look like? What does notice have to look like? Some of the technical aspects about the SWSP process. So we put rules in place that were applicable to just the South Platte and the Arkansas Basin. And now we're going through a process. We're going to refile them to make them applicable statewide. And so before we do that process of refiling, we just want to talk to water users around the state and see if there's input and suggestions that we should change those rules before we file them. So we're here to get input from you all about, should those rules say something different than what they say right now? So similarly, the Ag Water Protection Program about ongoing irrigation that is run by the CWCB, it has a document that guides the way it works, and that's called criteria and guidelines. Again, those were just established for the South Platte and Arkansas, and they're going to redo those to be statewide as well. So again, your input would be desired if you have any before they take steps to finalize that statewide. So right now we're traveling around the state doing these stakeholder discussions. Just like I said, we're expanding the SWSP rules statewide because we already had existing rules valid in the South Platte and the Arkansas. We're really not suggesting that to make a whole lot of changes. I have some slides at the end showing a few things that I think I want to highlight for you that we're suggesting to change. But we already have a good starting point. So the plan for those SWSP rules is that when we have a final version that we want to really finalize, we're going to file those in the water courts. So what we will do is make a filing in each of the 7 water division water courts, and then request that the court consolidate it into 1 water division. So everybody, who reads the water court resume will get that notice that we are filing those rules. But I want to point out that a rulemaking process for the state engineer is different from other types of water court processes. And that is that we don't have an opportunity to modify the rules, change the words of the rules within that water court process. Parties can become a party to the case, but there's no opportunity for anyone to modify the rules from what they were as they were submitted. So the time to provide your input on what the rules should really say is between now and when the rules are final. And then CWCB, they're going to be modifying the existing criteria and guidelines after DWR files their rules in the water court, hopefully later this year. That's when CWCB, actually, I think you said you were going to do your process beginning in September, Laura, if I remember.
I moved to November.
Okay.
This fall.
So also later this year. Okay, so now I'm gonna turn it over to Laura for her.
So this is the water protection program that is an alternative to the existing conservation programs. So eligible entities to create their new unique protection program are water conservation districts, water conservancy districts, irrigation districts, ditch and reservoir companies, nonprofit water providers, or a municipality. So I think the only one, noticeable type left out of that is an individual. So if you're an individual, you have to do one of those existing conservation programs. So this is what you would do if you wanted to create your new program. You would submit to the CWCB description, documentation, and maps, and telling us about your organization. You would also tell us about the area involved, the number of people involved. We would want to know especially about how you plan to monitor that ongoing irrigation, that 50% on the land still involved. So we want to know, what is your plan for monitoring that? When you submit that, we would post new proposals to our website and sponsoring entity provides written notice of proposed ag water protection programs to all parties on the SWSP list. And you would submit comments to CWCB within 30 days. Staff, like myself, would consider all these comments and provide recommendation and presentation at our board meetings. Our board meetings are public. We might need additional info, and ultimately the board will decide if they approve or deny your new ag water protection program. So an important part of the annual monitoring, that's an important part of your application, is to tell us about how you're going to do the inspections, how are you going to prove to us that you are continuing to irrigate, because the purpose of this is really to support continued agricultural productivity on that land still in production. We would review this every year to make sure that you are still irrigating that land, part of the program. So that's it for me. And like Tracy said, we are taking comments. You can comment on our website or directly to me via email, just about the criteria.
I have a question.
Yeah.
It looks like we're gonna be judging this based on the which irrigation as opposed to the water consumption.
Sorry, I'm not sure what your question too.
Sorry,
Can you say that?
We'll be measuring the use by the amount of acreage that's being irrigated as opposed to the amount of water coming into the field.
sorry, what's the question?
Is it based on the amount of water or the amount of land? And it's based on the amount of water.
Well, so I believe it's, you're allowed to use 50% of the historic consumptive use, so the amount of water for new use, but I think it's 50% of the acreage needs to stay in irrigation. So it's both acreage and consumptive use. Does that make sense? Yeah.
But you also have to have that, you got 2% of your turn flow would have to go through the thing as well, right? Because that's how you're gonna, if you have your turn flow is 4 CFS, so you'll have guaranteed part of the plan is that 2 CFS, right? You can assume that the 50% is gonna keep the return flow.
Maintenance of your return flows for the half that you're using. So there's different methods of maintaining your historic return flows, and those can vary. So for instance, some water users will use a release of water from storage to maintain their return flows, especially through the winter time. If you have winter return flows in a basin where there's a downstream call in the winter. So if that's where your historic return flows are going to be maintained from, then you could consider if some of that water that was prior to recreating can go to the new use. So it can't be more than 50% of the historic consumptive use. But that might be a way for you to maintain return flows if you get a contract with somebody else who's got water in storage. So there's different ways of maintaining those return flows. It can sometimes not be possible to do it with your irrigation water if you need water in the winter for return flow replacement. So sometimes you have to partner with someone else. Sometimes people use recharge ponds on their property maybe not very common in Division 6. But sometimes that's a way to retime things, is a way that to make them winter return flows. It's more common in other divisions, maybe. Yeah. So this is, commonly this type of thing, like the way that you might maintain your historic return flows, it might be something you'd work with like an engineering consultant on, or maybe when you're going through the water court process, you'd be thinking about, okay, well, you know, down the line, what's gonna be my method for maintaining those historic return flows? It is a tricky aspect of any change of water, right? Is, okay, what am I gonna do with those winter return flows? If you're in a location where you need to provide them. It depends on what the regime in your street system. I don't know, Brian, if you would add to that, you know much more about Division 6 operations. No, no. Would you have winter return flow requirements? I think about like, think about calls for hydropower that might happen in the winter. No call in the winter, so maybe that's not a consideration here in Division 6. And I've done most of my work in Division 1, so I feel a little uninformed about your street system here. Maybe not something you have to worry about very much.
I have a question, and I'd like to know these process. I get pretty sick of this. Can I go, oh, that very quickly? Even when I got my these processes.
So your historic consumptive use, 50% of that is 3 CFS, and that's what you're taking to a new use.
Like in your example, you take 3 into the.
Yeah.
3 to the irrigation. So
Yeah.
3 irrigation. It's a free river, so
I don't see why not. I mean, that's not under water, right? You're making a new appropriation, so I don't see any reason, you know. Constitution allows that, I don't see any reason why you couldn't. No prohibition against that. What else? Okay. So just jumping back to our timeline, so. Sorry?
So that 50% that you found, is there any requirements of what can and do that percent?
Of the land? Well, in fact. Sorry, I'm trying to thoughtfully respond to your question. I think in most cases, it's gonna be fallowed. I mean, maybe you want to dry land farm it. There's not necessarily a requirement for it to be fallowed.
So you can
That's
still-
sort of just the default
I
of
mean,
like,
for us, it's a hay system, so thinking about it, right, like you irrigate 50% of land, but there's still gonna be grass growing on the other 50%.
yeah,
Since you're gonna have to hay or do something with, it's not like
mhm,
self-plow, you just don't plant it. You
Yeah.
let it sit for every you could,
yeah.
raise it, you do other things,
I've had people ask me about concepts like split season irrigation on that land, or trying to somewhat like minimally or irrigate it less than you historically have. And so none of those concepts are prohibited. I think that a real challenge of that is that you need to show that you're preventing injury. So you need to show you're not expanding the historic use of that irrigation water, right? So how are you doing that? And I think, I just think overall that's a challenge with some of those different concepts of like split season irrigation, or concepts of conserving but still irrigating. So I think there's just a lot of information that we need to know about, like, okay, so how much are you consuming total with half the water that you're putting on? So the short answer to your question would be that's not prohibited. But I think those are, there's a lot of challenges with showing that you're not expanding the use of that water. The 50% that you're still irrigating with, so. Maybe you'd have another source of water that you could put on. What you're not irrigating with that water rate you change. It could get complicated, but. I hope people come up with creative ideas here. I think there's room for that.
So if you move 50% of that water off of the decreed area.
Yeah.
Say you pumped it somewhere
Uh-huh.
and then move the water there, that'd be acceptable
For irrigation, you mean?
for irrigation or whatever. So I mean, let's say I've got my hay fields in front of you, right? But now I need to get water to that hay field across the street, which is high,
Uh-huh,
but that's
that's gonna be your new use.
that's not in the
50%.
decreed area.
Right, but that's where you wanna use the 50% for a new use, is just at this higher location. Yeah, so that's what would be approved under the SWSP, so the SWSP could allow that pumping. Cause the SWSP is allowing an undecreed use of that 50%. But you're gonna apply through the through the state engineer's office for that operation, pumping to the higher fields. And they can approve that for a year, so that could be allowed under your SWSP.
So people could expand to higher grounds
Right,
than just the flood irrigation.
right,
Yeah, but you gotta have still. You gotta have your return flows be the same. Alright. Flood irrigation, that's 50% less. So you're sending your flood irrigation bottom to the top. Now, you can't expand now.
That's what I was asking. You could expand your irrigated land.
You cannot expand your
so,
expanding some stuff.
yeah, so. The typical way that one would think to do this is that you dry up half of your farm. And then you take half of that water somewhere else. So I thought in your example, you're gonna dry up half your farm and you're gonna take half of it to some higher ground.
But
So
if you're
that-
not flood
that-
irrigating, if you're using sprinklers or whatever, you're using less water. So your main area would still get the water.
Yeah, so
That's where. it
I
gets-
don't think that you can't just simply expand your irrigated acres without expanding the historic consumptive use. I mean, without getting into a lot of detail, when we go from like flood to sprinkler irrigation, we tend to have similar historic consumptive use. You're gonna reduce your amount of return flows though, so.
Yeah, your sprinklers will reduce your return.
Yeah, and so we still have to maintain our return flows. We can't expand the amount of historic consumptive use beyond what we did historically. And if we're taking half of it somewhere else, you can only use half of it for ongoing irrigation on your farm. So, it's not a way to simply irrigate the same land and irrigate more land. I don't think that's gonna work unless you're doing something where you're really quantifying how you're actually consuming less water on the lands that you have. So I think that's a pretty big scientific challenge for folks right now to show that they can irrigate the same lands but consume less.
It's up in a case by case basis.
Yeah, you could think about like maybe lower water use crops, but again, I'm not sure that you can cut your consumption by 50%. I'm not really an expert on that. I'm kind of looking at Robert in the back to see if you want to add anything here. If you guys don't know Robert, it's from the Department of Agriculture and a longtime irrigator. Would you add any, sorry to call on you from the back row,
Thanks a lot.
is there anything you'd add? You don't have to.
No, you're right. I think you really have to make sure you're not measuring expense.
Yeah,
It would be up to you and analysis of the subsidy water supply plan.
yeah,
I do have a question for you.
okay.
Is that because you've gone through water for it and you've determined rates, the sort of something to use? Does that limit me as a farmer then to try some new crops that may be using different amounts of water?
For your ongoing irrigation while you're operating under SWSP? I don't think so, there's any prohibition on that, so. I'll keep the answer short, I don't think so. Yeah. Okay, so. Our timeline, this is our last in-person meeting, outside of divisions 1 and 2, the South Pat and the Arkansas. We're gonna have one more virtual meeting in September, middle of September. And then we're hoping to file the SWSPs in the water courts in late 2025, so, you know, later this fall. CWCB is that gonna move forward with their process, so I guess I've kind of already said that. So if you're gonna have comments on the rules, if you can get those in by October 15th, that'll just allow us to move this process along. So on our website, we do have a lot of information. You can see those draft rules. There's a Google form there where you can submit comments about those rules. That front and back beginner's guide to Ag-PWR is also there, which is kind of summarizes what we've talked about tonight, the way that an Ag-PWR works. So all that information is there for anyone who has questions or wants to provide input, I guess. The next few slides, I think I have 3 or 4 slides that do get into some of the changes that we're suggesting for these rules that we want to file statewide. But it's not going to drag on forever. Okay, here's what our web page looks like. So when you do get to the web page, you can see the short link up there, the QR code that would get you right to it. You do want to click on where it says Rulemaking Ag-PWR, because then that expands. Accordion's open, that section of our website. All of our public meetings are listed there. An orange box shows you where you could submit comments. And you could also submit them via email. Marie's email is there, Nora's email is there. And then the draft rules are there in that box. So that's where you would find everything. Okay, onto the rules. So the rules are SWSP rules, just about how you're going to apply for an SWSP, what sort of things need to be submitted, and what GWR is going to do in processing that. So what you see here, the red lines are really the blue and green lines. Those are changes from what was in place for divisions 1 and 2 that is now we're proposing to be statewide. So previously, we had suggested that your SWSP application should provide information on dry up. You're going to take 50% of this water somewhere else. We're expecting that you're going to dry up 50% of the land. That's sort of just what we were presuming. But we did get feedback from some water users that they wanted the flexibility in these rules for other kinds of concepts, different types of alternative irrigation methods. And so this modification here is trying to allow that flexibility for people to say, I do want to do some limited irrigation on that land where I'm taking away a lot of the water. You know, I have a pasture or whatever. And so, so now we've changed the rules to allow for that kind of flexibility. And so that is that 3.1.8.1.2. If requesting alternative irrigation approaches, provide a description of the request and information supporting how such an operation prevents injury. And then also we got a question about, well, can I rotate the acres that I'm going to dry up over the 3 years, or that I'm going to irrigate over the 3 years? And we think that would be fine. You just have to tell us up front which lands are going to be dried up, what are going to be irrigated in that year 1, year 2, year 3. So that wasn't something conceived of before either. What is this one? Okay, this one is somewhat technical, but the rule used to be talking about the use of exchanges in the SWSP process. And we wanted to expand that to also allow the use of something called a water exchange project, which involves exchanging water that's not immediately available in the stream system. It might be water related to well pumping or water that's been recharged. Those things are happening off the stream, and there's a time delay between when well pumping or groundwater recharge impact the stream. So this was just broadening the language to allow for water exchange projects. That one's kind of technical. Okay, and then statute said that we needed in our rules to allow an appeal of the state engineer's final decision. But I had that slide where I went through all of the ways where people can provide input in the process. So participate in the water court case, provide comments on the SWSP application, provide input after that initial decision where there's like a 14-day gap for people to provide input. So we've added 6.2.2 that says, if you're going to appeal the final decision, which then goes to the water court, you should have provided input somewhere in one of those options you had up to that point. Don't just wait and appeal our final decision when you had so many opportunities. So we're putting in a limitation that if you want to appeal the final decision, you should already have provided comments in the process. Don't just come in at the 11th hour. That's what that one is. But that's the end of the slides that we have. Definitely have any questions or comments. There might be suggestions on the rules. Yeah.
What for like over